Hi there, this is Erica Merrill, and I am the founder of Perfect Legal Video, and it is Friday afternoon, and that must mean that I am with attorney Joseph Nivin out of New York City. Today, we are going to be talking about how to pay for your bills and who pays the bills while you're in the process of getting divorced. Welcome, attorney Nivin. Thank you so much for joining us today.
Thank you for having me.
Great. So this is a complicated topic. I mean, pretty much somebody's breaking up and some people are totally taken aback by it. They have no idea. They don't see it coming. And even if they do see it coming, some of these things drone on for years before they end, and they had no idea it was going to happen that day. It's almost like a death. You don't know when it's going to happen sometimes. And there are a lot of things left in the wake of that, and there's a lot of bills and a lot of childcare and a lot of things to consider. And today we're going to be talking about, how does that get sorted out? Now, we're talking about that. So you and your spouse are just splitting up, and they're fighting about who pays for what. What typically happens in this case?
Well, typically everything stays the same while you're going through the divorce. So I've definitely met people who are just dying to take their ex off certain things like, oh, well, I paid for all the car insurance. I want her off the car insurance. I've been paying for the storage facility that I don't want to pay for anymore, so I want to take her off. As a general rule, while you're going through the process, everything stays the same. Now, with that said, when people actually split up, then the court can issue orders, and in many cases has to issue orders for temporary maintenance and temporary child support. So what I always find is the best thing to do is that when people physically separate, once the court issues the orders of maintenance and support, so long as they exist, that we work out from the very beginning what is paid for out of the maintenance and support. So for example, let's say that we have a husband who leaves the marital home, and the court issues an order for maintenance and support. Now, usually the wife, so long as the husband was the moneyed spouse, is not used to having to think about the mortgage or the gas bill or the Con Ed, because she's so used to the husband taking care of all of that. And meanwhile, the husband's saying, well, if I'm going to be making this big payment every month or every week or every 2 weeks, I don't want to also be paying for the mortgage and the Con Ed bill and the gas bill. So we work out what is paid for out of that maintenance and support, and what does the husband still have to pay for outside of that order of maintenance and support. So this way we're not fighting over it while the divorce is dragging on.
So he or she, because I know plenty of women that are making more money than the man, and they end up having to pay the bills and the support. They have to pay what they were paying before, and if there's temporary orders, they could still pay for that, but it might bring the temporary orders down a little bit because that money's being considered as part of it. Is that correct?
Well, yes. If there's an order that somebody pay maintenance and child support and also pay for what are called carrying charges, things like the mortgage, the gas bill, the Con Ed bill, the car insurance, then if I'm representing the person that's be paying the maintenance and support, then I would certainly ask that at the very least the maintenance and support be lowered if my client's also going to be expected to make payments on the carrying charges.
Yeah, absolutely. Now, what if I'm the spouse that moves out of the marital home and I'm also the moneyed spouse? Do I still have to pay for all of the new bills and my new living expenses in addition to all of the bills for the house that I just left?
So in that case, typically I would, if I have the moneyed spouse and my client left the marital home and my client's been paying for the expense of the marital home, I would advise my client to do that until there's either a court order or an agreement stating otherwise. And if I'm that person's attorney, then what I would do is that I would try to get an order or an agreement that allows for all the expenses to get paid, but also ensures that my client can also make his or her monthly payments.
All right. So that's interesting. I know one of the questions that you have on here, you answered in the first part. So I just wanted to make sure I'm not repeating this as if I'm a robot, um, because I find all this interesting. So let's just say that sometimes people split up and they don't actually get temporary orders, and there's a long period of time, maybe even a year, maybe sometimes people divorces go on forever and they don't get those temporary orders. um I know you didn't write this in there. Let's just say that the spouse that is not the moneyed spouse ends up trying to, they have to use all their credit cards and everything that they have to try to pay the bills because the moneyed spouse isn't paying for those bills and there's no order for it. When they finally do get an order, do they have to go back and repay the money that they should have been paying all along?
Well, at the conclusion of a divorce, very often they make the orders retroactive to the date to the date when the application was made for those orders. So, for example, if we have the non-moneyed spouse who files for divorce and put in their application orders of temporary maintenance and child support, then very often the final orders are retroactive to that date. But at the same time, if they didn't make that application in the order in their initial filing, and then they file a motion for that order, then the order is only likely to be retroactive to the date when they made the motion. So it's very important that if you're the non-moneyed spouse, you could potentially be entitled to maintenance and child support, that you make sure in your summons with notice, that's the paper that starts the divorce, that you put in that you're requesting an order of maintenance and child support.
What if it was the other spouse that did the filing and you?
Yeah, then it's important to put in what's called your answer and counterclaim that you're seeking an order of maintenance and child support, because that's when you make the application, when you file your answer and counterclaim.
I see. Now, let's say that all of this goes smoothly and there is, no hiccup and all, there are orders and everything's in place, but the spouse does not end up making the payments that they're supposed to. And now it's putting the family in a bad position. If they have kids, that makes things very difficult.
Mhm.
And they're not living to the standards that they're used to, and maybe not great standards at all. What happens then?
Yeah. So you can file an application for contempt. And if you prevail on that application, the court finds that the failure was willful, meaning they're able to make the payments and just chose not to, then it's actually mandatory that the court issue an order that the other spouse pay your counsel fees. They would issue a judgment with interest, and potentially, if it's really egregious, or if the court finds that the only way that you could actually recoup the money that you're entitled to, then the court can actually incarcerate the spouse that failed to make the payments.
Wow. And you know what? I know that in the past, you and I have spoken about the orders that are not followed and how it can get as bad as, the worst thing is getting thrown in jail. But before that, they'll take away your license, your driver's license, your licenses that you might have professionally. They'll take away your visa. They'll take away lots of things. They'll garnish your wages, and then they'll throw you in jail. So there's like a little hierarchy of things that happen. But this is one of the cases where that hierarchy would go into, that chain of events could go into play.
Well, for child support, then they can take your license and all that. So if you were already supposed to receive support through what's called the support collection unit, then that's pretty much automatic, that if they go a few months without making child support payments, then they will suspend driver's licenses, they will suspend recreational licenses. And I know that it's pretty, it's one of the things they'll do is suspend professional licenses, but that's a whole other process because, for example, if the payor was an attorney, then actually has to go to the appellate division, but they will suspend your law license if you go a few months without paying child support. For maintenance, it's not as easy because maintenance payments cannot go through the support collection unit. Now, if you apply for what are called child support enforcement services, then they actually will, so long as your ex-spouse was working on the books, they will deduct the child support and also the arrears payment, the arrears from the paycheck. That's pretty much automatic, but if necessary, you can go to court, and that's when they'll give you a money judgment with interest. They'll order that he pay your counsel fees or she, and they'll also put the other person in jail if necessary and issue what's called an undertaking, which is, it's like bail, but for child support. If you pay this amount, then you get out of jail.
Yeah, and I think I probably told you the story. One time I got this phone call from somebody I used to work with, and it was a long time ago, and we weren't even that close. He was like my sales manager or something, and he was sitting in jail, and it was for child support, and he was just calling every possible person he knew, and I was just completely in shock. And I'm like, I didn't help him out because like I didn't know him at all, and and I hadn't heard from him in years, and I didn't know him that well anyway. So it was definitely an interesting situation. But so I know it really does happen. They'll throw you in there, and usually you said those get paid really quick because.
Oh yes, yes. Yeah, I used to do assigned counsel work, and yeah, I think the most I ever saw somebody go was a weekend. They call mom, they call their brothers, their sisters, everything. One guy called his boss, who actually happened by pure coincidence to be in family court for his own case. And his boss came down and made the payment and retained me for his case.
Wow.
Yes, it was quite an odd situation. But
yeah,
I remember.
Everyone in your phone, you just call everyone.
Yeah, well, they take away your phone. They cuff you. They take everything and they put you downstairs. I remember I would go down. Like I don't do these cases so much anymore, at least not on the respondent side, because whenever people come in, I say, well, instead of paying me, you should pay your child support. I represent people that are, trying to get order support that's owed to them. But when I was assigned counsel, I'd get these cases all the time. So I remember taking my pad and going down to the cell and saying, okay, who do you know? And writing down their names, their phone numbers, getting on my cell phone upstairs, calling mom, brother, sister, girlfriend, everybody, and then giving them the instructions on how it is that they would, make the payment, get the receipt, go down to the detention center and get their loved one out of jail.
That's such a process, and embarrassing. That's super embarrassing. These are people that probably never thought they'd be in jail in their life. It's probably the one and hopefully only time they were in jail, and it's probably freaks them out.
Well, it's the whole spectrum. There's some people are fairly used to it, and then there were other people that were quite taken aback.
Oh, I'm sure it runs the gamut. Now that's super interesting. Now, I know when they're making the arrangements for temporary orders of child support and child visitation. What do you say? What do you say? Parenting time. I'm not sure, like if you guys are in New York.
In Supreme Court, they usually say parenting time, but in family court, some still say visitation.
Okay. I don't know why, but it's like a PC thing. So I want to make sure I don't say it the wrong way.
Because you don't visit your own kid. You parent your own kid.
Exactly. So that's probably a good change. But all right. So when they're figuring all this out, and let's say that there was a parent that stayed home and took care of the kids, or maybe had part-time work instead of their big career that they used to have, so that the other parent could go be the big breadwinner and work on their career, and someone could be at home taking care of the kids, or at least available if kids are homesick, vacation, get home early, or whatever it is, and now they don't have the money to pay the bills because they're the ones that chose to do the non-paying job of taking care of the kids for the most part. What happens if they're considering this, and this person used to have a big job or several diplomas and should be making $100,000 or whatever it is, and now they're making less than that, a lot less than that?
Right. So inevitably, if it's hotly contested, the moneyed spouse would ask that the court impute income to the non-moneyed spouse, meaning say, okay, even though he or she is not working, he or she is capable of making this amount, and therefore the court should consider that to be their income. But if the person's been out of the workforce for long enough and was to raise the kids, then that person would be a good candidate for maintenance. Now, with that said, given that the minimum wage in New York City now is $15 an hour, I have seen that if that all the children are school age, the court will typically impute minimum wage to the non-moneyed spouse, because I mean that person could get a job working for minimum wage 40 hours a week. So that's something that I'm seeing more and more now with the new laws. But if the person's been out of the workforce for a while on the other side, and the other spouse makes a lot of money, they will typically award maintenance. With respect to child support, no matter how much the custodial parent makes, or used to make for that matter, then they will issue an order of child support for somebody who's clearly the custodial parent.
Right. And they'll take into consideration what they could be making, but also who has the kids, who's going to have the kids the most, and they look at the parenting time and how it's divvied up, because you'll pay more or less depending on how much you have the kids as well. Is that correct?
Yes and no. It's not mandatory, but somebody who has the kids at close to half the time would have a good argument that the expenses that they have during their own parenting time bring down the personal expenses for the custodial parent, and that is a good argument for what's called a deviation from the formula, meaning paying a little bit less than what you would pay if you only had the kids every other weekend.
Yeah, no, that's true, because then now they're paying just as much for food as the other parent, or just as much as clothing and that sort of thing. So they'll take that into consideration.
Yeah, almost always.
Now, these are the questions that we have for the day. Typically, at the end of our time, you have some kind of an interesting story to tell us, and sometimes some additional information that we didn't cover. Do you have anything that you'd like to add?
Interesting. As a cautionary tale, I do have, I do know of a case where the person was making payments which were much more than what he could afford to pay at the beginning voluntarily, and the court just ordered as the status quo, and it pretty much depleted everything that he had because it wasn't something that was sustainable. So what I'll say is that it's really a cautionary tale that if you're making support payments in the beginning, just remember that the other side is going to get used to it. So if you're making voluntary support payments, make sure that it's something that's sustainable. It's very important to make sure that the other side has expectations that are reasonable, and they don't just make voluntary payments that you won't be able to keep up with during the pendency of the divorce.
Exactly. Now, I mean, the other thing could happen too, where they could be paying a lot before the filing, and before, they're used to paying everything, and then all of a sudden, once they file for divorce, as a strategy, which you pointed out in one of the recent interviews, they might start paying a lot less, even though they can afford a lot more. And they might cut things off, like credit cards, or certain accounts don't get paid anymore that you're used. It's definitely an interesting situation when this in between limbo period comes into play. Have you seen that happen before, where they start off with a lot, and then as a strategy they pay very little and try to get the other non-moneyed spouse to run out of money so that they can't afford to really get a lawyer or fight the way they should for the equal rights in the divorce?
I have, but it's a very, very stupid thing to do, because I mean, as the moneyed spouse, the law is not as keen on protecting you as the law is keen on protecting the non-moneyed spouse. So if the court starts to see divorce planning, then the non-moneyed spouse can really have a field day and just use it to cast aspersions on the moneyed spouse's credibility. The court's very much used to seeing people who have a lot of money lying about it. So if the moneyed spouse starts crying poverty right after cutting off credit cards and drastically bringing down support payments beyond what's reasonable, then the non-married spouse can say, well, don't believe anything this person says, because look at what look at what they were doing. And it could be a very effective strategy.
Yeah, I mean, especially since it's all right there on paper. I mean, you can see when someone's lowering the credit card that the family used and increasing their own personal credit card limits, and it's just a lot of crazy stuff going on during this limbo period. And I think it's like one of the most interesting parts of a divorce.
Yes, I think right at the beginning is when people can really set the tone for the rest of the case. So I do tell people all the time, I know it's not fair, keep everything the same, because if they can see that you're being a good guy, just as long as something that they can keep up, even if it's not necessarily something they want. If I say, they see that you're being a good guy, then I can really make you more sympathetic to the court and make sure that the result is something reasonable.
I have a kind of a fun question, and it's sort of related, but is it true that January is one of the biggest times for divorce filings?
Oh yeah, we see it. Just I think it was last week. One day we got a whole lot of calls, and yeah, the dark joke was New Year's resolution.
Oh, yeah, you get through the holidays with the kids, and nobody wants to drag the family through that during the holidays. So they kind of sit it out, and where other fields of law are really slow during this time of year, you guys really have a lot of business pickup in January.
Right.
On another note, I know I've talked to you about this, and I want everyone to kind of keep their eyes open. I'd like to have a panel interview on Valentine's Day about dating tips from family attorneys, talking about, because you see what happens at the end, talking about maybe what people can do to make their next choice a little bit better. Do you ever think about that when you're in there with people?
Oh yeah.
Of course, you're like, why didn't you see these red flags?
Well, I definitely try to have what I've learned from doing this is that this area of life is where reason just goes out the window. I mean, I really don't think that there are that many people that do what people ideally should do and sit there and say, well, here's my litmus test. Do they meet this? Do they check this box? They check that box? They check that box? That when people get feelings for each other, then that really goes by the wayside. But I think that the bigger thing is, I think that the decision for the most part about whether or not to marry someone is more of an emotional one than an intellectual one. That the bigger question is, what can people do when they feel that this is the person for them? What do they do to make sure that it's a happy marriage and that they don't end up in a position where they need this kind of advice?
Exactly. And even if it's uncomfortable, protecting themselves before they go into it, because you don't think of it as a business arrangement in the beginning. It's all love and romance, but in the end, that's all it is a business relationship that's dissolving.
Right.
So we've got a preview what's going to happen when we talk about this, but it should be a really fun topic. So everyone stay tuned for that. I know you sent over next week's topic. I didn't get a chance to look at what it is. So why don't you tell us?
So much has happened since I sent that email. It was unmarried spouses, unmarried couples. What happens if you have kids and you're separating?
Ooh, I love it. It's going to be really interesting. All right. So everybody, let's stay tuned for next Friday. We're going to be talking about if you don't get hitched, but you're separating and you have kids, and there's a whole new set of problems there, and a whole new set of strategies and things to consider. So I know it's going to be a really interesting talk. Thank you so much today for enlightening us on what to do when you're in limbo of your divorce. And I hope you have a fantastic weekend. We really appreciate your being with us. And thank you, audience, as well.
Same to you. Have a good weekend.
Okay, we'll see you soon. Bye bye now.
Bye.